Every time a wealthy person dies, their family doesn't go to court. Their assets move quietly, privately, exactly the way the dead person wanted. No judge, no waiting room, no 18-month legal process eating 5% of everything they've built. Your family does go to court, but nobody told you about the thing that makes that not happen. It's called a trust. And here's the thing, a trust is not some secret rich person weapon. It's a legal tool that has existed for centuries that normal people can and do use, and that most people have never had explained to them in a way that makes any sense. So let's fix that. A trust is actually quite simple. Well, no, not really, but it's closer to simple than you'd think, okay? Stick with me. At its core, a trust is a legal container, a box essentially. You put your stuff in the box. The box has rules about what happens to your stuff. And then when you die, the box follows those rules without needing a court to sign off on anything. That's it. That's the whole concept. The complexity is in the details of how the box works, who controls it, and what kind of box you're building. Let's talk about who's involved, because a trust has 3 characters and confusing them is where most people get lost. Character 1, the grantor. That's you. You're the one creating the trust, putting your stuff in it, and writing the rules. Grantor, settler, truster. Different lawyers use different words for the same person, which is very on brand for the legal profession, honestly. Character 2, the trustee. This is the person who manages the assets inside the trust and carries out the rules. In most everyday living trusts, the kind a normal person sets up, you are also the trustee. Meaning, you create it, you manage it, and you control it while you're alive. You're wearing 2 hats, totally legal. Character 3, the beneficiary, the person who actually benefits from the trust. It could be your kids, it could be your spouse, it could be your golden retriever legally in some states, which is a sentence I didn't think I'd have to say out loud, but I guess that comes from Taylor Swift and her $100 million cat that she has. But anyways, so in the most common setup, you create the trust, you manage it, and at some point in the future, your kids get the stuff. You are the grantor and the trustee. Your kids are the beneficiaries. 3 roles, 2 people. Cool, but how does any of this actually protect anything? Here's where the mechanism matters. When you create a trust, you don't just sign a document and call it done. You have to fund it. This is a step that most people who set up trusts completely forget to do, and it is also the step that makes the trust either work or be a total waste of money. Funding means you literally transfer ownership of your assets from you as an individual to the trust. Your house doesn't belong to you anymore, it belongs to your trust. Your brokerage account doesn't belong to you, it belongs to your trust. You retitle everything. The trust now owns your stuff. And here's why that matters. When you die, the government doesn't have an automatic process for dealing with stuff you personally owned. That's called probate. And probate is the courtroom nightmare that trusts are specifically designed to avoid. Let's talk about probate for a second, because most people have heard that word and have no idea what it actually is. Probate is a legal process of validating your will, identifying what you owned, paying your debts, and distributing what's left to your heirs. Sounds organized, right? Well, it's not. Probate is public, meaning anyone can walk into a courthouse and look up exactly what you owned and who got it. Probate takes time. We're talking about 9 months minimum, often 1 to 2 years, sometimes longer if anyone contests to anything. And probate costs money. Attorney fees, court fees, executor fees, typically 3 to 7% of your gross estate. Not your profit, the gross value of everything you owned. On a $500,000 estate, that's up to $35,000 just to legally hand your stuff off to your kids. A trust skips all of that. Because the trust owns the assets, not you, there's nothing for the court to process when you die. Your successor trustee, the person you named to take over when you're gone, steps in, shows the death certificate, and starts distributing things according to the rules you wrote. No judge, no waiting room, no 3 to 7% lost. This is why every estate attorney you've ever met has tried to sell you a living trust. But here's where it gets more interesting. So far, we've been talking about a revocable living trust. Revocable means you can change it whenever you want. You can add assets, remove assets, change the beneficiaries, dissolve the whole thing on a Tuesday if you feel like it. You remain in control. The trust is just a very smart legal wrapper around your stuff. But here's a second kind of trust, and this is the one that gets genuinely weird. An irrevocable trust. An irrevocable trust is exactly what it sounds. You put assets in, you give up control, you cannot take them back, and the trust is now its own thing, a separate legal entity, and you are no longer the owner of what's inside it. Now, why would anybody do that? Because the IRS agrees with you. If the trust owns the assets and you have no control over them, the IRS does not count those assets as part of your taxable estate when you die. The federal estate tax exemption right now is around $13 million per person. So most people aren't losing sleep over estate taxes. But once that exemption sunsets in 2026, it drops roughly in half. For anyone sitting on a business, real estate, or investments pushing into that territory, removing assets from your taxable estate through an irrevocable trust is the move. And it's not just taxes. Depending on how it's structured, an irrevocable trust can protect assets from creditors, from lawsuits, and from a future divorce. Doctors, lawyers, business owners, anyone with serious liability exposure use these as a legal firewall. The trade-off is real though. You give up control. You genuinely give it up. If you put your house in an irrevocable trust and then decide you want to sell it for any reason, you cannot just decide that. The trustee, who is now someone other than you, has to approve it. The rules you wrote when you set it up govern what's possible. So you have to be very sure, and you need a very good attorney. Now, you might be wondering, okay, but does any of this actually matter if I'm not rich? Short answer, yes. Long answer? Also, yes. You don't need a $10 million estate for a trust to make sense. If you own a house, one house, and you have kids, a revocable living trust is probably worth the $1,500 to $3,000 in attorney fees to set up, because without it, your house goes through probate. And probate in most states is going to cost more than just an attorney and fees alone, before you count the months of delays and, all that other stuff. The trust doesn't save you in the moment, it saves the people you leave behind from dealing with a slow, expensive, public legal process during what is already a terrible time. There's also a control element that doesn't get talked about enough. A trust lets you write actual rules. You can say, my kids get money at 30, not 18. You can say, funds can be used for education and healthcare, but not for anything else. You can say, if my kids get divorced, their spouse doesn't touch this. A will hands people a lump sum. A trust hands them a lump sum with instructions attached. That's the mechanism. You create it, you fund it, you name your people. You write the rules, you die, the trustee follows the rules, your family avoids court. Most people skip this step because nobody made it sound like something they needed to know. Well, now you do. That's going to cost you 1 subscribe, and I will see you in the next video. Also, guys, disclaimer, this is educational content, not legal advice. Talk to an estate attorney for anything specific to your situation.